Hi, thanks for checking out Right Law Group's video page. Today I want to touch on a couple of questions we've had about what to expect at a jury trial. And this is going to be general information. If you want any specific information, feel free to contact us. I'm always happy to make new videos regarding different issues you may have or questions you may have. But today we're just going to talk generally about the jury trial process and what you as a client or a potential family member of a client can expect during this process. So there are two different kinds, technically there are three different types of levels of jury trial. What I'll focus more on is the misdemeanor and felony, but I'll touch on all three for you just so you have an awareness of what's going on. When you're charged with a criminal offense, it can be either a misdemeanor charge, a felony charge, or a petty offense. Petty offenses are things like jaywalking, minor traffic tickets, even urinating in public is a petty offense. It's just great. If you're charged with a petty offense, the question of whether or not you're entitled to a jury trial relates to whether or not that potential offense carries the possibility of jail time. If you are facing a potential jail sentence, then you qualify for a jury trial. Now, at the petty offense level, let's say, for example, you have a minor traffic ticket in municipal court. You can qualify a minor traffic ticket, let's say careless driving. You can qualify because you have the potential of going to jail from anywhere from 10 to 90 days according to the statute. So you do qualify for a jury trial, but jury trials in municipal court are a little bit different. You can only have 3 people on your jury panel at a municipal jury trial, or you can have what's called a bench trial, and that's where the judge actually hears your case. Now, with municipal court, you have 3 people in your jury panel. A bench trial, you can actually have at any level of any criminal offense. So misdemeanors, petty offenses, felonies, you can always just have the judge sit and listen to your case instead of having a whole jury. That's really a question that you and your attorney need to flesh out and decide strategically what the best option is for you. Generally, though, with misdemeanors and felony levels, we're going to be looking at having a jury trial. The main differences between misdemeanor and felony trials is that for a misdemeanor, you're entitled to a panel of 6 jurists, and for a felony, you're entitled to a panel of 12. So let's take a basic DUI case, for example. When you're preparing for this with your attorney's going to go over the facts of the case. They'll go over the discovery with you. They'll talk to you about kind of what they're looking at as far as issues in the case. And generally, it's pretty cut and dried. You're going to be going in on the morning of trial. Here in El Paso County, our trials usually start somewhere between 8:30 and 9 in misdemeanor court. And you go in, you sit there next to your attorney, and it's your right, of course, to remain silent. You don't have to testify. You don't have to do anything in this case. And under the law, your attorney doesn't have to do anything either because you are presumed innocent until they actually prove you guilty. But if you have an attorney that's worth anything at all, they're going to be working real hard for you. When you are in this trial, what will happen is you're sitting there. Generally, court decorum requires that the person who's accused of a crime sit further away from the jury and the DA actually sit closer to the jury. So let's say you go in and the jury panel's over here to the left, the district attorneys will be sitting here, and then the defendant and their attorney will be sitting to the opposite side, and then you have the judge in front of you. Sometimes the district attorneys have what's called an advisory witness. On DUIs, like the example we're using here, an advisory witness is someone who's sitting with them, helping them. So in DUI cases, it's usually the DUI officer. Some DAs do it, some don't. It's a matter of their own personal preference. The judge usually allows that, though, and it's the officer or the advisory witness doesn't get to ask any questions. They're just there to help the attorney out, keep things organized, and help them throughout the jury process. Now, during this process, on a misdemeanor level, you're going to be going through this process called voir dire. It's jury selection. At a felony level, you're looking to have 12 different people impaneled on your jury. At a DUI or misdemeanor level, a DUI so long as it's a misdemeanor DUI, you're going to look for 6 people to be on your panel. Different judges do this process different ways, but the general idea goes like this. What happens is the goal of jury selection, and frankly, this is the most interesting part of jury trial that you never really see portrayed on TV. So if you're ever interested, you should go check out what happens. Courtrooms are open forums, anyone can go watch. But this is the process that is the most important part, in my opinion, of a jury trial, selecting the jury. When you have a jury come in, you have all the potential panelists. For, let's say, a DUI, you have maybe 25, 30 people called in for jury selection. On a felony charge, say assault of some kind, you can have possibly 40 to 60 people. On a sex assault case that's more serious, you could have hundreds of people called in for this job. With the misdemeanor level, you have them called in. They usually are going to be sitting in the courtroom, and then you're going to have a few in the box there, and it's the attorney's jobs to cull through these potential jurors to figure out who the best juror is for this case. If you want a little bit more information on voir dire and the full process, I have another video that goes more fully in depth as to what's going on in that process. But the general issue that you're looking at is the DA gets to question the people and the defense attorney gets to question them, and then everyone makes selections as to who sits on the jury. Same with felony. When you have your jury selected, then you have opening statements. Each attorney gets to get up and make opening statements. The DA always gets to go first, then the defense attorney. Then you have the presentation of evidence. It's the DA's job to present all the evidence they think they need to prove the charges beyond a reasonable doubt. And this is where it's very, very important that your attorney is paying attention and listening, because there are specific elements that the DAs have to prove in order to get over what I call halftime. So they'll present their entire case, they lay it all out, and then they're done, and they rest. You'll see this in movies where it says, the people rest. At that point in time, if the DA has failed to prove all the information necessary to potentially have a jury find you guilty beyond a reasonable doubt, it is your attorney's job to stand up and make a motion for what's called a judgment of acquittal. Now, it's not always necessary. So if the DA has proven everything beyond a reasonable doubt, potentially, then you don't need to make this motion. But if they're missing something, the defense attorney should get up and ask for a judgment of acquittal, meaning that the DA hasn't done their job, they haven't proved everything that they should have done, and so the judge just should dismiss it right there. Very rarely does this happen, but it's something to be aware of. After that halftime motion is made, then the defense has the opportunity to present any evidence. Now, during this time, in a DUI, like I said, a lot of the times you're not going to have very much information to present in your defense, and you're not required to. You're considered innocent until proven guilty otherwise. So the defense then presents their evidence if they have any, and they rest. At that time, the judge is going to go over jury instructions with the jury, and this is an incredibly boring process, just so you're aware. The judge is going to read from a book, verbatim, read the jury instructions to the jury, and the jury is required to follow those instructions only. But it's important to have your attorney working on these beforehand. They'll communicate with the district attorney and the judge and make sure that all of these jury instructions are in line with your case and they appropriately apply to the facts of this specific case. After jury instructions are read, then the final opportunity comes for attorneys to make final statements, otherwise known as closing arguments. The district attorney will get up, they make their closing argument, and then we have our chance to make our closing argument. Since the presumption and the burden of proof is on the DA, they then get the chance to make what's called a rebuttal closing. And this is where it's slightly unfair and frustrating for us, because the DA gets the chance to talk again. They get to get up and rebut whatever we say. And it's because the burden of proof is on them. So just be aware, if you're sitting there with your attorney and then the DA gets to talk again, we don't get to talk again. We get one shot at the apple. But as long as you have a good attorney, one shot is all you need. After that, the judge will tell the jury that it's now their time, and they get to take the case back and review all the facts of the case and make a determination. So then is the waiting period. A lot of the times, you can't predict how long a jury's going to be out. I've seen juries be out anywhere from a few minutes to hours to days. It really depends on the specific people on the jury, the charges, and how involved they get with it. But after that happens, the jury will let the judge know they've reached a verdict. Everyone will come back to the courtroom. The jury will give their verdict to the judge, and the judge will announce whether they have found the person who's been accused either guilty or not guilty. In a nutshell, that's kind of what a jury looks like at the criminal and misdemeanor and felony levels. Again, there are a lot of different nuances and a lot of different things that happen at different levels. For more information on voir dire or jury selection, feel free to see our other video. I go a little more in depth as to what you can expect in those situations. And as always, if you have any questions, if you'd like to see any more videos on certain aspects that I touched on, just feel free to leave us a comment below. Thanks so much.